Okay guys, welcome back to part 4, the Uniform Commercial Code. And this is another lengthy part, an important part for me to explain to you. I'm going to try to do it as quickly as I can. The Uniform Commercial Code was started in 1942 and completed in 1952. It took 10 years to do this. And they changed over to this code, switching America from what we call public law to public policy. Basically the common law and sovereigns switching over to the slave law and admiralty maritime jurisdiction. That's a simple way to kind of explain what happened. I've learned all of my stuff on the Uniform Commercial Code from what we call a constitutionalist and patriot, a master named Howard Freeman. Howard Freeman was I'm going to say very old man, but at the time he was born in 1900. So, and he passed away in 1992. So the man, if he'd still be alive, he'd be 115 years old today. And he was very knowledgeable. He tells you that he wasn't a lawyer, but I think he worked in the insurance industry, but he was very smart. They look at this man as one of the best teachers, educators in the Constitution for the United States of America and common law and so forth. Okay? Ralph Epperson is the person who did this. This was done in 1990, or taken from Howard Freeman, one of his speeches or seminars, and he, took it from the tapes and all the information and translated it into this book. If you can find this, I highly recommend you do it. Now, I've read parts of this in different videos of mine on my channel, but I'm going to go a little deeper and into it as best I can. But here it is. It's I would say underground book. I don't know where you can even find it. It's called the U.C.C. Connection, Free Yourself from Legal Tyranny, a review of the Uniform Commercial Code, U.C.C. by Howard Freeman, constitutionalist and patriot, reviewed by Ralph Epperson in 1996. So this stuff is, I won't say old information, but this was thoroughly explained by this gentleman back then, and I really, I've learned so much for this. I've had this for so many years, and it was only until 2012 I got frustrated and tired, or I won't say frustrated, but tired of police pulling me over for stupid things and bothering me. And I've always known about this, but I never studied it. It was hard. It takes time. It's not something you're going to learn in one day, believe me. It takes time and dedication of yourself to sit there and really understand what is being said here and research it and so forth. And that's what I finally started to do. And that's why I have the videos, excuse me, on me fighting, in court under the Uniform Commercial Code. Anyway, so public law versus public policy. Just to set it up, because this is, a book, so I want to get into the important parts. What Mr. Freeman had found was he was helping a friend in court, and they were quoting Supreme Court cases or cases prior to 1938. The judge ended up ruling against him, and he caught up with the judge, like whatever, in the elevator or whatever, and said, "Well, why would you rule against me?" And the judge told him, I don't make rulings. Anything prior to 1938 cases in my courtroom don't apply. Anything after 1938, I will acknowledge and will rule on that. And he didn't understand why, and he was saying, well, what's the difference and what's going on? And that particular judge wouldn't tell him. So what happened was there was a case in 1937, 38, somewhere around there. I mean, it's in the law books. They're saying it's argued January 31st, 1938, called Erie Railroad versus Tompkins. And this is what the judge was talking about, where it went from common law into contractual law. So I'm skipping around, but so Mr. Freeman always told people, look, don't go in the courtroom being harsh and demanding and telling the judge you're going to follow the law, you're going to do what the law, because if you come off like a wolf, and they're just going to fight you back. You got to go in there and play kind of dumb, or be very humble and like sheep, and just listen and say, just play dumb, I guess he's saying. Play a little dumb, ask a lot of questions. So that's what he did. And one day, and I'm going to start reading it. A friend in court from this point on, and I'll try condense it as much as I can, but there's just so much you got to get here that I can't really condense it. Fortunately, I made a friend of the judge. Now you won't make friends with the judge if you go into court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into court as a wolf, you make demands and tell the judge what the law is and how he had better uphold the law or else. Remember, verses, I send you out as sheep in the wolf country. Be wise as a serpent and harmless as a dove. We have to go into court and be wise and harmless and not make demands. We must play a little dumb and ask a lot of questions. Well, if I ask a lot of questions and box the judge into a corner where they have to give me a victory or admit what they didn't want to admit. I won the case, and on the way out I had to stop by the clerk's office to get some papers. One of the judges stopped me and said, "You're an interesting man, Mr. Freeman. If you're ever in town, stop by, and if I'm not sitting on a case, we will visit." America is bankrupt. Later, when I went to visit the judge, and this is Ralph Epperson, he quotes and fills in gaps or what he feels. Epperson, I can remember that during one of our meetings, Mr. Freeman revealed that this judge was in actuality a retired state Supreme Court justice from his home state of Wyoming or Montana. He further stated that this judge had asked him not to reveal his identity because he could get in a lot of trouble by revealing too much. I told him of my problems with the Supreme Court cases dealing with public policy and public law. He said in 1938, catch this, and I've already read this before, but in other videos, but this is deep. He said in 1938, all the higher federal judges, the top attorneys, and U.S. attorneys were called into a secret meeting, Epperson, by President Roosevelt. And this is what the president told them. The president explained that America was a bankrupt nation. It was owned completely by its creditors. Epperson. The creditors, according to Mr. Freeman at another time, were the international bankers who had loaned America all the money they had created, that had created the national debt. Mr. Freeman explained that the reason they had declared America bankrupt was because this nation had called in all of the gold behind this nation's money and had suspended the redemption of paper money into gold, and was required by the very money the American people and the bankers were carrying. This meant that this nation had in essence defaulted on our contracts with anyone who owned a gold certificate. This permitted its bearer to exchange the paper for actual gold at any time the bearer wished. So they were declaring this nation to be bankrupt, and since they now owned all of this nation's assets, they were telling this government that they would be required to henceforth adjudicate all cases under the Uniform Commercial Code and not the Constitution, meaning the guarantor of the common law. But they had to make us subject to the jurisdiction of this new Constitution. And they did that through several methods. The passage of Social Security Act. There's no law requiring sovereign state citizens to get a Social Security card, so they trick us by making us think that we must get a card when it is a voluntary act, as I've already covered. The requirements that all babies get a birth certificate. We used to enter the details about the birth of our child in the Holy Bible, and that ended it. In the need to obtain a driver's license, we are travelers, not drivers. And only drivers have to get a driver's license. Car registration, we pledge our car to the state as collateral for the debt we owe the bankers, etc. And I've covered all that. These are called adhesion contracts, meaning a two-party contract in which both parties are obligated to perform some activity. And also, too, from what I understand, the adhesion contract also means it's a contract where you either sign it or you don't. You're not forced to. So, the creditors of the Congress, they own I'm sorry, the creditors own the Congress, right? They own the executive, they own the judiciary, and they own all of the state governments. Ampersand. I added the opening phrase of the following comment by Mr. Freeman since this part of my copy of the transcript could not be made out. I believe that Mr. Freeman would have said, "We," meaning the federal judges and attorneys, were told to take silent judicial notice of this fact, which means we were to never reveal it openly. We were told that our court was to operate in admiralty jurisdiction and that we could call it anything we wanted, but that we were never or not to call it admiralty law. Admiralty courts. The reason that these judges cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under the common law. In admiralty, there is no court which has jurisdiction unless there's a valid international contract in dispute. If you know it is admiralty jurisdiction and they have admitted on the record that you are in an admiralty court, you could demand that the international maritime contract to which you are supposedly a part and which you supposedly have breached be placed into evidence. No court has admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. You get it? So you say, just like innocent excuse me, just innocently like a lamb, well, I never knew that I got involved with international maritime, so I deny that such a contract exists. If this court is taking jurisdiction in admiralty, then place the contract in evidence so that I may challenge the validity of the contract. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are their slaves. Not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every asset of the nation. The reason that they don't want to tell everyone that they own everything is that there are still too many privately owned guns. There are uncooperative armies and other military forces. So until they can gradually consolidate all armies into a world army and all of the countries into a single world court, meaning the new world order, ampersand. There are many who are claiming that the coming new world order is a world government, or as in this case, a world court. That opinion is simply not correct. In my book entitled The New World Order, I carefully document the evidence that it is a new civilization, an entirely new way of looking at how we live our lives. In other words, those in favor of the New World Order want to change the basic order of things to remake our civilization. See, that's, you know, where we have differences of opinion of what it is and what they're trying to do, but in generality, my opinion is you know what's going on. They're trying to consolidate this into a new world order and put us enslaved, you know, as slaves and shackles again. You know, it's ugly. Back to Mr. Freeman. It is not expedient to admit the jurisdiction of the court. Excuse me. It is not expedient to admit the jurisdiction the courts are operating under. When we understand these things, we realize that there are certain secrets that they don't want to admit, and can use this to our benefit. Please forgive me for stumbling over it. Just one of those days. Jurisdiction. The Constitution of the United States mentions 3 means of jurisdiction in which the courts may operate. 1, common law. Common law is based upon God's law. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do anything you please as long as you do not infringe on the life, liberty, or property of someone else. You also have the right to make a fool of yourself, provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any action by the government which prevents a man from making a fool of himself. For instance, when you cross over state lines in most states, you will see a sign which says, "Buckle your seatbelt. It's the law," or "It is the law." This cannot be common law, because who would you injure if you did not buckle up? Nobody. This would be compelled performance. But common law cannot compel performance. Any violation of the common law is a criminal act and therefore is punishable. The next law, equity law. Number 2, equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So if you have compelled performance, there must be a contract somewhere, and you are being compelled to perform under the obligation of the contract. Now, this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of the contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court, which is a criminal action. Are our seatbelt laws equity laws? Question. The answer to that question is they are not, because you cannot be penalized or punished for not keeping to the letter of a contract. Third, number 3, admiralty maritime law. This is civil jurisdiction of compelled performance, which also has criminal penalties for not adhering to the letter of the contract. But this only applies to international contracts. Now we can see what jurisdiction the seatbelt laws and all traffic laws, building codes, ordinance, tax codes, etc. are under. Whenever there is a penalty for failure to perform, such as willful failure to file, this is admiralty maritime law, and there must be a valid international contract in force. Are you getting this? However, the courts don't want to admit that they are operating under admiralty maritime jurisdiction, and also that they had taken the international law or law of merchant and adopted it into our codes. That is what the Supreme Court decided in Erie Railroad case, that court decisions would be based on commercial or business law, and that it will have criminal penalties associated with it. Since they were instructed not to call it admiralty jurisdiction, they decided to call it statutory jurisdiction. You may ask how we got into the situation where we can be charged with where we can be charged with failure to wear seat belts and be fined for it. Isn't the judge sworn to uphold the Constitution? Yes, he is. But you must understand that the Constitution in Article 1, Section 10 gives us the unlimited right to contract as long as we do not infringe on the life, liberty, or property of someone else. Contracts are enforceable. And in the Constitution, there are 2 different jurisdictions mentioned where contracts can be enforced. They are equity and admiralty. But we find them enforced in statutory jurisdiction. This is the embarrassing part for the courts. But we can use this to box the judge into a corner in their own court. We will cover this more later. Did you get all that? That's some deep stuff. And that's the basis of all of these traffic courts and a lot of other courts. Contracts must be voluntary. Under the common law, every contract must be entered into knowingly, voluntarily, and intentionally by both parties, or it is void and unenforceable. These are characteristics of a common law contracts. There is another characteristic. It must be based on substance. For example, contracts used to read, for $1, 1 dollar, 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 1 I will paint your house, etc. That was a valid contract. The dollar was a genuine silver dollar. Now, suppose that you wrote a contract that said, for one Federal Reserve note and other considerations, I will paint your house. And suppose, for example, I painted your house the wrong color. Could you go to a common law court and get justice? Question. No, you could not. Because a Federal Reserve note is a colorable dollar and therefore has no substance. And in common law jurisdiction, that contract would be unenforceable. So you start understanding the money system. They had to change over into the Uniform Commercial Code to govern the new colorable money, the fiat money, the fake money, because it used to be real substance prior to that with gold and silver. So he'll explain a little bit of that when I explain. Colorable money, colorable courts. The word colorable means something that appears to be genuine but is not. Maybe it looks like a dollar and maybe it spends like a dollar, but if it is not redeemable for lawful money, silver or gold, it is colorable. If a Federal Reserve note is used in a contract, then the contract becomes a colorable contract. And colorable contracts must be enforced under a colorable jurisdiction. So by creating the Federal Reserve notes, the government had to create a jurisdiction to cover the kind of contract which uses them. Ampersand. It might assist the reader to get another understanding of what Mr. Freeman just said. The Constitution requires the government to issue lawful money, meaning a money based upon gold and silver. A contract that two people signed that dealt in lawful money could be enforced under the terms of the common law when the international bankers were no longer getting their money redeemed in lawful money. The Federal government could not force them into a common law court because they were no longer subject to the terms of the common law. They have the right to move the jurisdiction of all of their cases to another court, a colorable court, where colorable money could be transferred under contracts between two parties. But they had a problem. The people of the United States could not know about what just happened. They could not let them know, or they would rebel and demand a return to the Constitution and lawful money. So they took silent judicial notice of the fact that the court system had changed. We now have what is called statutory jurisdiction, which is not a genuine admiralty jurisdiction. It is a colorable admiralty jurisdiction that the judges are enforcing because we are using colorable money. Let's see how we got under this statutory jurisdiction. Deep, huh? When you're understanding and you start to get this, it really begins to open your mind and you begin to understand how we've been duped. Uniform Commercial Code. The government set up a colorable law system to fit the colorable currency. It used to be called the law merchant or the law of redeemable instruments because it dealt with paper which was redeemable in something that had substance. But once Federal Reserve notes had become irredeemable, there had to be a system of law which was completely colorable from start to finish. The system of law was codified as the Uniform Commercial Code and has been adopted in all states except Louisiana. I already explained that to you. Or did I? I don't remember if I did. Forgive me. The Uniform Commercial Code, I think I did, said that they fall under a different law system. They fall under Roman or under Roman law and Napoleonic law is what they call it. The state of Louisiana didn't follow the Uniform Commercial Code. Now, I from what I understand, they've adopted all parts of it as of today, except 2. But so they say, you know, certain things may not work there because of that reason. That's why only the state of Louisiana did not adopt the Uniform Commercial Code. But like I said, most of it has been, now they use it and have adopted it. So just a bit of information. Sorry if I forgot if I mentioned that in the beginning or not. This is called colorable law and is used in all of the courts. I explained 2 of the keys earlier, the first of which was the country had been declared bankrupt, and the second was that we had no rights. If the master says jump, then the slaves had better jump, because the master has the right to cut off their heads. As slaves, we have no rights. But the creators, masters, had to cover that up. So they created a system of law called the Uniform Commercial Code. This is colorable jurisdiction under the Uniform Commercial Code. This colorable jurisdiction under the Uniform Commercial Code is the next key to understanding what has happened. Now, there are some that I understand that argue and say that they don't like the Uniform Commercial Code because it was created by government, and it's not something that was considered under the common law. But looking at it, on my view, is yeah, but it allows you to switch it back into the common law, because at the time there was no purpose for a Uniform Commercial Code because we were dealing with common law and real gold and silver. But once they changed that, they put this in there to allow the people who knew or know how to do it to switch back this case from amity, maritime jurisdiction, or from that fiat colorable money back into the real common law, you know. So that's my view on it. Okay, contracts or agreement. One difference between common law and the Uniform Commercial Code is that in common law, contracts must be entered into, and you all know this, knowingly, voluntarily, and intentionally. Under the Uniform Commercial Code, this is not so. First of all, contracts are unnecessary. Under this new law, agreements can be binding, and if you only exercise the benefits of an agreement, it is presumed or implied that you intend to meet the obligations associated with those benefits. If you accept a benefit offered by the government, then you are obligated to follow to the letter each and every statute involved with that benefit. The method has been to get everybody exercising a benefit, and they think they don't even have to tell the people what the benefit is. Some people think it's a driver's license, the marriage license, or birth certificate, etc. But I believe it is none of these. Compelled benefit. I believe the benefit being used is that we have been given the privilege of discharging debt. We give substance for substance. If I bought a quart of milk with a silver dollar, that dollar bought the milk and the milk bought the dollar. Substance for substance. But if I use a Federal Reserve note to buy the milk, I have not paid for it. There is no substance in the Federal Reserve note. It is worthless paper, given in exchange for something of substantive value. Congress offers us this benefit. Debt money created by the federal United States can be spent all over the continental United States. It will be legal tender for all debts, public and private, as it says on its face. And the limited liability is that you cannot be sued for not paying your debts. So they have said, we're going to help you out, and you can discharge your debts rather than pay your debts. When we use the colorable money to discharge our debts, we cannot use a common law court. We can only use a colorable court. We are completely under the jurisdiction of the Uniform Commercial Code. We are using non-redeemable negotiable instruments, and we are discharging debt rather than paying debt. That makes sense. Remedy and recourse. Every system of civilized law must have two characteristics, a remedy and recourse. Remedy is a way to get out from under the law. The recourse is if you have been damaged under law, you can recover your loss. The common law, the law of merchants, and even the Uniform Commercial Code all have remedy and recourse. But for a long time we could not find it. If you went to the law library and asked to see the Uniform Commercial Code, they would show you a shelf of books completely filled with the Uniform Commercial Code. When you picked up one volume and started to read it, it would seem to have been intentionally written to be confusing. It took us a long time to discover where the remedy and recourse were found in the Uniform Commercial Code. They are found right in the first, volume at U.C.C. 1-207 and U.C.C. 1-103. Now remember what I told you in the beginning about how they revised it to 1-308. 1-207 is still in effect. You can go look it up and see for yourself. It's still in use, or still is valid. Okay, so just keep that in mind. Now, because I'm reading this at the time before they changed it, so when I read this, understand that I'm reading it as it's written here, without, you know, telling you any more from this point on about the revision of it. Remedy: the making of a valid reservation of rights preserves whatever rights the person then possesses, and prevents the loss of such rights by application of the concept of waiver of estoppel, U.C.C. 1-207.7. It is important to remember when we go into court that we are in a commercial international jurisdiction. If we go into court and say, I demand my constitutional rights, the judge will most likely say, if you mention the Constitution again, I will find you in contempt of court. Then we don't understand how he can do that. Hasn't he sworn to uphold the Constitution? The rule here is you cannot be charged under one jurisdiction and defend yourself under another. For example, if the French government came to you, not a French citizen, and asked you where you had filed your French income tax in a certain year, do you go to the French government and say, I demand my constitutional rights? No. The proper answer would be, that law doesn't apply to me. I am not a Frenchman. You must make your reservation of rights under the jurisdiction in which you are charged, not under some other jurisdiction. So in a U.C.C. court, you must claim your reservation of rights under the U.C.C. 1-207. This section, that section goes on to say in section U.C.C. 1-207.9, when a waivable right or claim is involved, the failure to make a reservation thereof causes a loss of the right and bars its assertion at a later date. You have to make your claim early. Furthermore, in U.C.C. 1-207.4 it says, the sufficiency of the reservation, any expression indicating an intention to receive rights, is sufficient, such as without prejudice. Whenever you sign any legal papers that deals with Federal Reserve notes in any way, shape, or manner, write this above your signature: without prejudice, U.C.C. 1-207. As I already told you, I have to say it here because I want people to mess up. And now it's U.C.C. 1-308. But you can still say formerly 1-207. When you use this phrase, you are reserving your rights. You can show at U.C.C. 1-207.4 that you have sufficiently reserved your rights. It is very important that you understand just what this means. For example, one man used this in regard to a traffic ticket. When asked by the judge just what he meant by writing without prejudice U.C.C. 1-207 on his statement to the court, he had not tried to understand the concept involved. He only wanted to use it to get out of the ticket. He did not know what it meant. When the judge asked him, he told the judge that he meant that he was not prejudiced against anyone. The judge knew that the man had no idea what it meant because his statement was wrong and he lost his case. You must know what it means. And I tell people that all the time, how important it is for you to understand what it stands for. Without prejudice, U.C.C. 1-207. When you use this phrase in connection with your signature, you are saying to the government, Ralph or Emperson, Mr. Freeman recommends that we must memorize this. I reserve my right not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, and intentionally. And furthermore, I do not accept the liability of the compelled benefit of any unrevealed contract of commercial agreement. That's what it means. And you can repeat that. It takes time to learn it. I understand that, but that's why I'm putting it here for you or explaining it to you. What is the compelled performance of an unrevealed commercial agreement? Question. When you use Federal Reserve notes instead of silver dollars, is it voluntarily? Question. No, there is no lawful money. So you have to use Federal Reserve notes. You have to accept the benefit. The government has given you the benefit to discharge your debts with limited liability, and you don't have to pay your debts. But if you do not reserve your rights under this section of the U.C.C. 1-207, you are compelled to accept the benefits and are therefore obligated to obey every statute, ordinance, and regulation of the government at all levels of government, federal, state, and local. If you understand this, you will be able to explain it to the judge when he asks. And he will ask. So be prepared to explain it to the court. You will also need to understand U.C.C. 1-103, the argument and the recourse. If you want to understand this fully, may I suggest that you go to a law library and photocopy these two sections from the U.C.C. It is important to get the Anderson edition. Some of the law libraries will only have the West Publishing version, and it is very difficult to understand. The Anderson copy is broken down with decimals in 10 parts, and most importantly, it is written in plain English. Now, I hope you all understand it. That's how you go and research this stuff. And I know that in some cities, like for instance, my uncle is from the Chicago area, and you know, they took it out, the books, and he asked them, well, where are they? He said, so somebody took them. Yeah, I bet. So it's a lot of conspiracy going on there. They don't want people to be reading this and understanding it and its application. Recourse. The recourse appears in the U.C.C. 1-103 at 1-103.6, which says, the code is complementary to the common law which remains in force except where displaced by the code. A statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. This is the argument we use in court. The code recognizes the common law. If it did not recognize the common law, the government would have to admit that the United States is bankrupt and is completely owned by its creditors. But it is not expedient to admit this, so the code was written so as not to abolish the common law entirely. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights at 1-207, you may then insist that the statutes be construed in harmony with the common law. If the charge in court is a violation of a traffic ordinance, you may demand that the court produce the injured person who has filed a verified complaint. If, for example, you were charged with the failure to buckle your seatbelt, you may ask the court who was injured as a result of your failure to buckle up, or a failure of me to buckle up. However, if the judge won't listen to you and just moves ahead with the case, then you want to read to him the last sentence of 1-103.6, which states, the code cannot be read to preclude a common law action, ampersand, defined as to mean ignore, meaning not allow. Tell the judge, Your Honor, I can sue you under the common law for violating my rights under the U.C.C. I have a remedy under the U.C.C. to reserve my rights under the common law. I have exercised the remedy, and now you must construe this statute in harmony with the common law. To be in harmony with the common law, you must come forth with the damaged party. If the judge insists on proceeding in the case, just act confused and ask this question. Let me see if I understand, Your Honor. Has this court made a legal determination that sections 1-207 and 1-103 of the Uniform Commercial Code, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he answers yes, then say, or then you say, I put this court on notice that I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge knows this, so once again you have boxed him into a corner. See that? But I have to say, following this now, with so many people figuring out and using it and whatever, they're slamming you in the courts. I've been there and done it and see what they're trying to do. Because they're being bombarded. This is, this information is coming out. I know other people on YouTube are, reading the same stuff, and it's getting around, which is good. But we got to keep the pressure on these courts and on the government. And there's a lot of people too who use this, I've told, and they use it and then they think that it just automatically gets dismissed. No, I mean, it's supposed to, and it'd be great, but they know that people are just using it without, like I read the example about the man saying without prejudice just means I'm not prejudiced against anyone. They don't get the understanding of what it means. You got to understand the meaning, because you're going to have to explain it to the court, and once they know, they still may not let it go or whatever. But there's a lot of things that they do here with the trickery of this. They try to intimidate you. They try to do everything in the courtroom, to frustrate you. And typically what I found is you lose always in the first round or two, because they're trying to make you give up. And so therefore you have to go and appeal and this and that, and then finally it gets to the point where you're just like, hey, whatever, it's just like, geez. And I've been there, or I'm there. That's what happened in my last case. They got me on a technicality, because I was told one thing by the court, and then I was told another thing by this court, and they just, they won't hear the case because I got wrong information from the previous court of when my filing date was, and they said in the Court of Appeals that I had passed that date, and so this is the kind of tactics and game. I shouldn't even be there to start with, because I did everything in a timely manner, and it was read in court and everything, but that's the way that they're playing the game. They're playing hard because they realize what's at stake. Think about it. I've said it before. They don't want their slaves to escape. How much money this is dealing with. So it's a war. This is a war going on that people have no idea. And I'm telling you, they're going to have to do something quick to squash this, or try to, with some type of new terrorist attack or some new law. You can't do this or that, or some, and with all this stuff going on with the police stuff and the rioting and the cities and so forth, martial law. And get into all that in here, FEMA and the martial law, and them declaring that, and then everything goes out. Everything is under Admiralty, Maritime Jurisdiction, martial law. So anyway, another little part I wanted to get into and explain to you is deep. It's another part of law that you have to understand, and this is long too, but I'm just going to try to cut it to you, just say it like this to you. All laws don't apply to us. What you may think is law is not, because there has to be enacted public law or positive law. They go together. And then there's private law and special law, which are not actual law. So let me read this to you briefly, because this is a very important part that I'm adding in here. That when I went looking over all of my stuff and all my books and papers and things like that I've had over the years. Listen to this. Public law is a law or statute that applies to the people, generally of the nation or state, adopting or enacting it. Is denominated, a public law, and contradistinguished from private law, affecting only an individual or a small number of persons. Black's Law Dictionary, 6th edition. The court refers to public law as positive law and is defined as positive law, law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. Black's Law Dictionary, 6th edition. An example of the foundation which I have presented above is expressed by the California Supreme Court when it stated, taxing and licensing statutes are not enacted as positive law, which consists of those statutes enacted by legislative bodies in pursuance to authority or mandate granted in United States or California constitutions. Such tax and licensing statutes are private, equity maritime law contracts which are entered voluntarily by private persons with the private corporate state. Escovedo versus State of California, 35 CAL .2D 870. Emphasis added. The above two paragraphs show the application of positive or public law and how it affects different objects or subjects. The ensuing paragraphs shall explore the meaning and application of private or special law. Private law, that portion of the law which defines, regulates, enforces, and administers relationships among individuals, associations, and corporations as used in contradistinction to public law. Black's Law Dictionary, 6th edition. Special law, one relating to particular persons or things, or made for individual cases or for particular places or districts. One operating under a selected class rather than the public generally. A private law, a law is special when it is different from others of the same general kind or designed for a particular purpose or limited in range or confined to a prescribed field of action or operation. A special law relates to either particular persons, places, or things which, though not particularized, are separated by any method of selected from the whole class to which the law might, but not such legislation, be applied. Black's Law Dictionary, 6th edition. The California Supreme Court has applied these definitions to their practicality, to the practical sense in the following declaration. A general or public act affects the whole community, whereas a private act affects only particular persons or private concerns. Ex parte Burke, 59 CAL 6, a selected class or particular object. Earl versus Board of Education, 55 CAL 489, and Smith versus McDermott, 93 California CAL 421. And just this last part here, because this is really deep. The above paragraphs establish an insight into the type of law, confirming that their respective objects or subjects are not the same. Now we must consider how they are being applied to us in their administration. It is in the administration of these private or special laws that we average individuals experience limitations which impacts his freedom. When governmental agencies attempt to enforce these laws, they are proceeding under the presumption that each and every individual is the proper subject or object of the law. Under administrative law, the agency is permitted to proceed under these presumptions. Remember, in law, all presumptions are rebuttable. Excuse me, jeez. If an individual is ignorant of the fact that he is not the proper object or subject of that law, he will acquiesce to it because of his fear of punishment. It is this appearance of law or color of law which allows the honest law-abiding citizen to be brought under the control of laws that do not apply to him. The United States Supreme Court recognizes this reprehensible state of affairs when it declared, because of what appears to be a lawful command on the surface, many citizens, because of their respect for what only appears to be law, are cunningly coerced into waiving their rights due to ignorance. United States versus Milker, 350 U.S. 179 at 187. Do you understand that? This is what I'm talking about. This type of coercion, misrepresentation, and flat out deceivery, lies that our government is partaking. There's much more, but I just don't want to keep on with all of it. I want you to understand the importance of what I'm trying to tell you so far in these 4 parts of how this all comes together. Now, I think I've covered everything on that I need to cover. So I'm going to go ahead and go to part 5. The income tax hoax. So stay tuned with me on that, and see you then.